Then, Millers, now I come to the governor's decision. Now, Millers, your Lordship knows that under the Constitution, there are areas where the governor has discretionary powers, subject to 3 exceptions which are given in Nabum Rebia. This is an area when, in the beginning, Millers, there's an election that takes place. Who is to form the government? There is enough discretion with the governor. He will see as to whether there's a pre-poll alliance, and if the pre-poll alliance has majority, he'll call the leader in the normally. I mean, there are exceptions. There's a post, if he doesn't get a pre-poll alliance majority, he'll call a post-poll alliance. And if not, he'll otherwise see if a majority can be cobbled up by a leader who has the confidence of the House, who may have the confidence of the House. That discretion is always with him. Now, we are talking of the discretion of a governor post the formation of a government. That's the first issue. So, post the formation of an elected government, if 10 people go to the governor, what is his discretion in the matter? Because the governor has to ascertain, one, that look, these people along with others, the leadership that I will administer the oath to will have the confidence of the House. That's one criteria on the basis of which he'll swear in him. 2, he will ask the question, which party do you belong to? He's naturally have to ask. I am sure he will know that before even he asks that question. So he knows, that the Shiv Sena is not before him. On the 30th, he knows Shiv Sena is not before him. So what is his discretion in administering the oath of office to Eknath Shinde? Except the fact that all the 39 rebels will support, or the BJP, along with the 39 rebels, will oust the government and will support the new chief minister. He also knows, there is a disqualification petition pending. So your lordships will have to decide for the first time, in situations of this nature, when there's already an elected government in place, and there is a taint, alleged taint, of a certain set of members pursuant to the fact that disqualification proceedings are pending, whether the governor can exercise discretion in a manner which will topple an elected government, not await the outcome of the disqualification proceedings. The governor could have done 2 things. Could have said, I know for a fact that there is a disqualification notice against you all, or against 16 of you. You who want me to administer an oath of office to want to be the chief minister. The court has given you time till the 12th of July. Please first file your reply on the 12th of July. See the outcome of those proceedings. And if there is no taint as far as your membership is concerned, I will administer the oath of office to you. That, I think, is a constitutionally moral path that the governor ought to have adopted. Because institutional morality demands that he follows that path. The Constitution, in fact, persuades him to follow that path. Why? Because there's an elected government in place, of which he was a member. He himself. Eknath Shinde was a member. So why would a governor administer oath except that he himself knows that the elected government will be toppled? That's a very serious matter, according to me, Malaj. You looked at the Sarkaria Commission report, Malaj, your lordships will find no such eventuality, Malaj, considered. The governor,
eventualities are to be considered on experience.
That's true. That's true. Because ultimately, democracy only thrives when institutions uphold the sanctity of the Constitution. And quite frankly, Malas, and this is again my personal opinion, no court, no institution should balk from that, should withhold its hands from that. Because ultimately it's the message sent by court, by institutions, that we are above the vicissitudes of fortune that come with politics. That's the only way, Malas, to gain respect within the public and to uphold the values for which our forefathers gave us this republic. But unfortunately, that's not to be. So, Malas, here there is a big conundrum, very big conundrum. So first, Malas, the 27th order, the 29th order, then the governor. Even the governor could have stopped it. When he even chose not to stop it. So your lordships will have to evolve some principle in the context of, because this, if Nabam Malas is not overruled, this will happen time and again. And the governor will play, I'm sorry to say, Malas, I have seen the governor, it happened in Arunachal. Played ball. And we have seen, Malas, and I mean no disrespect to the institution of the governor, we have seen governors performing a more proactive role as institutional heads within the state, which has created disturbances within the polity. So, therefore, how your lordships will evolve a principle to ensure that constitutional morality is upheld is something that I leave it to your lordships. I cannot give an answer. I can only say in the facts and circumstances of this case, the governor should not have administered the oath of office to Eknath Shinde, because he was not the leader of the Shiv Sena. There was a pending disqualification petition against him. He belonged to the Shiv Sena, but had dissociated himself with the Shiv Sena. And he had no locus. Who was to go to supposing whether the Shiv Sena was to form a government with the BJP, who was to go to the governor? The leader of the Shiv Sena. That's the Paksh Pramukh, Uddhav Thackeray. It is he who would represent the Shiv Sena before the governor and say, okay, we want to join hands with the BJP. In what capacity was Eknath Shinde before the governor? In which capacity? And in which capacity did the governor accept or give him audience and administer the oath of office? And let us kindly see, Shinde has never disputed that, because he says, I am the Shiv Sena, and he has never disputed that Uddhav Thackeray is the Paksh Pramukh. He is not disputed even today. So in what capacity did he go to the governor? Where did he get authority from? Not from Uddhav Thackeray, not from the Paksh Pramukh.
Yes.
In fact, Maharaj, what the governor does in this process, it revives the concept of a split and allows it to be alive before him, even though para 3 has been deleted. Gives it legitimacy. Now, all this is violation of 21A. All this per se, Malad. What is the Speaker to decide? From the 21st of June, right up to 30th of June when he's sworn in, each act amounts to voluntarily giving up membership of the party. Each act. And under the 10th schedule, he has no defense. Because there's no amalgamation.